LoudLilDucky coming through, spitting truth, unabashed, calling out the liars, debunking falsehoods with a blast. I ain't afraid to say what's real, won't ever hold back. Gonna shake the system up, turn it all off track. I see through the smoke, the mirrors in the disguise, expose the hidden agenda. No more room for their lies. The truth is my weapon, I won't let it be concealed. I'm the voice for the voiceless, no longer gonna yield. In a world full of deception, I'm here to set it straight, bringing justice to the forefront. Won't accept their twisted fate. They may try to silence me, but my voice will still prevail. Sparking revolution, it's a truth-telling tale.
Hello, everybody. Welcome to the LoudLilDucky. Today, we are going to be going over the Laura Owens and stuff that she likes to do. She is scheming still while there are criminal charges pending against her for pregnancy scheming. So in the middle of all this, she decided that she was going to renew her restraining order against Michael Marraccini in California. Now, the thing is Rachel Mitchell can only do things that happen in Maricopa County. Could there be an area where Rachel Mitchell could do something because Owens lives in Maricopa County and she's filing it from here? Maybe. But California is going to have to take care of Laura Owens in regards to Mike Marraccini. And maybe she thinks because it is a different jurisdiction and it's in California that this shit can't be used against her in her criminal case. Maybe. Her lawyer probably would have told her otherwise. But who knows? It seems like she's possibly acting pro se in this, as she usually does. So it could just be her doing shit without a lawyer's advice. And we know that David Gingras has been a little preoccupied himself. So let's jump into the documents that were filed July 9th, 2025, and see what Owens has to say, because it seems like she omits things and stretches truths, exaggerates, or just flat out lies in these things. So, actually, first, before we pull that up, I am going to share the fundraiser. I also need to put it in the description. Okay. So here is Mike Marraccini's GoFundMe. He has raised $8,000, almost $9,000. Let's get him over that $9,000 hump for sure. And he says, thank you to everyone who has offered support, encouragement, and kind words. I truly appreciate it. I'm reaching out as I navigate a complex situation and began exploring legal options. Any support, whether through a small donation or by sharing this page, will help defray out of pocket costs and allow me to get started with legal advice. I am deeply grateful for any help during this time. Thank you for being part of my support system. So let's see what we can do in. All right. Hello, Denise. Yes, scheming is in Laura Owens' DNA. Okay, let's see here. Here is that, and then. All right. So Mike Marraccini's fundraiser is going to be pinned to the top of the chat. And let me add it to the defense fund. Or let me add the fund to. Why is everything all right? Marraccini. Okay. So now it is in. Now it is in two. It is pinned at the top of the chat, and it is in the description of this video. If you would like to donate, please go do that. He needs all the help that he can get against this crazy woman. We know that the Owens have a GoFundMe for Ron Owens' health. I don't know that that's really what it's for. Because he really shouldn't have bills with his age and type of insurance that he gets at his age. So, yeah. Yep. That is true, Denise. That is true. All right. Let's bring up. Now we're going to bring up the documents. So we're going to stop sharing that screen. Okay. I want to make this bigger. Okay, hopefully that works. Okay. So we have filed on July 9th, 2025, request to renew restraining order. Laura Owens says she's in Scottsdale. And so this is the Superior Court of California, County of San Francisco. So San Francisco County is going to be the one who has to handle the lying and scheming and fraudulent stuff and perjury and all that stuff when it comes to this case. But that doesn't mean that these public filings cannot be used against her in her criminal case here in Arizona. All right. Name of restrained person, Michael Marraccini. Current restraining order expires July 9th, 2025. Have you renewed this order before? Yes. How many times? 9. She has renewed this 9 times? What? And you get the temporary one, and that only lasts for so long, and then you get that's crazy. I mean, it's been several years, and if she has to renew it every year, I thought the last one was for, like, 2 years. 9 times, that's insane. Yeah. Mike needs to fight this once and for all. How long do you want the restraining order to be renewed for? Permanently. Maybe the last one was 5 years, I don't remember. Oh, okay. Alrighty. Oh god. Don't look at documents that way. Nothing here where you're supposed to write, "I'm afraid or worried that the person is into might abuse me in the future." B, the person in 2 has violated the order. Okay. Date violation happened. Various dates, including June 10th, 2024. Explain what the person did. She says, see attached declaration. So that's why she didn't write this out, because she attached a declaration. How often has this person violated the order like this? Other. She clicked the space for more attached sheet of papers. She did not check the box for lawyer's fees and costs. I think she asked for it in the thing, but we'll see. But she didn't check the box on the form. And then she signed July 8th, 2025. So she's filing for a renewal the day before it expires, which seems kind of last minute, but okay. Like, I would make sure my stuff didn't expire, but that was me. And that would be me being actually scared, which she is not. Laura Owens, lawyer in this case, in pro per. She is pro per. All by her lonesome. Yeah, because everybody else thinks this is ridiculous. Nobody wants to support you. Okay. She says he is a male, 6'4", 220, brown, green, white, 33. He just had a birthday in June, so happy belated birthday, Mike Marraccini. There was a hearing on September 11th, 2020 at 9 a.m. The person blank, the person in 2. Renewal and expiration. The request to renew the attached restraining order issued on July 9th, 2018 is granted. The attached restraining order is renewed and will now be effective for 5 years. Okay, so in 2020 to 2025, it was a 5-year one, like I thought. Okay, it was 5 years, like we thought. So that would be time 8. And then this time would be trying time 9. So in between the time of 20, there's no way she has tried to renew this 9 times. That is just a flat out lie in that first page. There's not, if this one was 5 years and the time before, like, she just lies. Okay. 9 pages are attached. All right. This one was July 9th, 2018. She had an attorney for that, which was Justin Cook. Okay. And in that one, she said that he harassed, attacked, threatened, assaults, sexually or otherwise, hit, followed, stalked, molested, destroyed personal property, disturbed the peace, kept under surveillance, impersonate on the internet, electronically or otherwise, or blocked movements. He contacted either directly or indirectly by any means, including but not limited to telephone, mail, email, or other electronic means. Yeah, doubtful. And you know why they have to list all these things? Directly, indirectly, by any means, but not limited to telephone, mail, email, or other electronic means for people like Laura Owens. Yep, that's why. Because she will contact you whether you block her or not. She'll make up new phone numbers. She will use aliases. She will use emails. And the reason that she thinks that everybody else is doing it is because she does it, when that's just not how it goes. But she is the type of woman, and the reason that all that has to be laid out, because if it's not listed, these crazy people will go the extra mile and be like, well, you didn't say social media. Take action directly through or through others, obtain the addresses or locations of any protected persons. I don't think he's gathering addresses, but all right. You know, he had the stay away order of at least 100 yards. You know, couldn't go near her dog either because apparently he wanted to punt the dog. I believe that was Marraccini that wanted to punt the dog like the football, is what she said. Okay. All right, so that was July 9th, 2018. So she's just attaching the history of this. And then this is the agreeing to 2-year restraining order. So this like twice. Okay, now we're getting to her ridiculous speech. Actually, let me go turn on a fan real quick because I am burning up. Let me see here. Okay, I'm going to take this down real quick. Okay, let's bring this back up. Lights are hot. And then here in Texas, it's really, really hot. And it's sticky. It's been rainy for July too. Alrighty, so here is Laura Owens' declaration and her reason for the renewal. My name is Laura Owens. If called to testify in court, I could and would testify to the following under penalty of perjury based on my own personal knowledge. Are you sure you want to do things under penalty of perjury, Owens? It didn't go so well for you last time. I currently reside in Scottsdale, Arizona. I am 35 and my date of birth is Nobody gives a shit because nobody wants to wish her a happy birthday. Summary of original petition and first renewal. In 2018, I filed a petition for an order of protection, OOP, in this court against my ex-boyfriend, Michael Marraccini, date of birth, in the case. Attached as Exhibit A is a copy of the declaration I submitted in support of my original petition against Mr. Marraccini, explaining the reasons I asked for the original OOP, which we have gone over that in previous Marraccini video. So we are not going to go over the original stuff. I have a whole playlist on Owens and Marraccini, or it's just in all the videos under the Bachelor is the one who exposed this cuckoo. My initial petition resulted in a 2-year stipulated OOP being issued by the court against Mr. Marraccini on July 9th, 2018. She underlined stipulated because he didn't fight it. A copy of the court's original order is attached here to as Exhibit B. We have seen that ridiculous order, but Marraccini didn't fight it. And so, that's the crummy part is Mike got, to me, horrible legal advice. And because he didn't fight it and he just stipulated it because he thought that it would just make everything go away, she would go away. And by this time, that she would be long gone, forgotten, nothing. But she wasn't. And so he's had this thing and he didn't fight it. And that was 2018. We're now in 2025. This is why he needs to fight it. He needs help fighting it. And she needs to be called out for all the lies that she has been spewing against him since 2018. Now she jumps to, in July 2020, I filed a request in this court seeking to renew the OOP against Mr. Marraccini. Attached as Exhibit C is a copy of the declaration I filed in support of the renewal request, explaining the reasons for the request. On September 11, 2020, this court granted my request to renew the OOP against Mr. Marraccini. A copy of the order granting a 5-year extension of the OOP is attached here to as Exhibit D. The current order is set to expire on July 10th, 2025 at noon. For the reasons explained below, I am now asking the court to renew the OOP against Mr. Marraccini permanently and to refer him to the United States Attorney's Office for criminal prosecution based on his intentional violations of this court's order. No. And you don't get to just refer people to the U.S. Attorney's Office. Just because you were referred to the U.S. Attorney's Office, you don't get to just flip-flop that, because guess what? You're not a judge. So you refer nobody. And I don't think the judge here is going to do that either, but maybe if you bat your eyelashes hard enough and play stupid like you always do. All right. Continuing on. Summary of recent violations by Mr. Marraccini. Since the OOP was renewed in 2020, Mr. Marraccini has violated it in several ways, most of which relate to a different family law case I am involved in here in Arizona called Owens v. Eckerd. I would be like, how many cases do you have against exes? Like, how many exes do you not have cases against? That might be a shorter list. Briefly, the Owens v. Eckerd case here in Arizona involved a petition to establish paternity, which I filed in Maricopa County Superior Court against a man named Clayton Eckerd. Mr. Eckerd and I were involved in a brief one-night relationship in May 2023. It was not a relationship. It was a one-night stand. You're a whore. After that experience, it was an experience, all right. I tested positive for pregnancy, which eventually led me to file the paternity case against Mr. Eckerd. No, I had HCG in my system that I put there. That is more like it. Ten. While the paternity petition was pending, I believe I had a miscarriage. There is no believing you had one or didn't have one. You either did or you didn't. With twins that you were 5 to 6 months pregnant with. I believe I had a miscarriage. You don't believe you have a miscarriage. You either do or you don't. And it is very obvious usually. And you've had so many weird pregnancy things, you should know. You know, you're like an expert in this and you believe you had a miscarriage. No, you had a period, bitch. I had a miscarriage, which was later confirmed by a visit to an OBGYN facility called Mom Doc, where I took 2 pregnancies, which both came back negative. Mom Doc did not deal with you during a miscarriage. You never went to a doctor to confirm whether you had a miscarriage or not. You went there so that you could finally get a negative test and end this facade because the walls were coming in on you. Mom Doc did not deal with you during a miscarriage. You're omitting a whole bunch of shit here. Because you're bleeding that you so-called believe you had a miscarriage supposedly happened in July or September. And then you went to deal with your miscarriage in November at Mom Doc? No. Lying liar who lies. After receiving this information, I took no further action to pursue the paternity petition against Mr. Eckerd, which resulted in the court setting the matter for administrative dismissal due to inactivity. I also decided not to tell anybody about this until at least a month or so later. And then it was announced in court in February. Omitting a bunch of shit. I just kept my miscarriage a secret the entire time. I had a miscarriage, but I was still going for paternity. 11. Before the case was dismissed, Mr. Eckerd hired a lawyer who accused me of faking the pregnancy. After the lawyer threatened to seek sanctions against me, I hired a lawyer who immediately moved to voluntarily dismiss the paternity action with prejudice, as permitted by Rule 26 of the Arizona Rules of Family Law Procedure. Oh, yay, Rule 26. She thinks she knows about Rule 26. But see, she has been misinformed about Rule 26. But, she thinks, her lawyering. She knows all about the Rule 26 rules. Even though the Arizona rules required the court to allow me to withdraw the paternity petition, the judge refused to allow me to withdraw the petition. You were allowed to be done with the paternity part, kinda. Like the parenting time and stuff like that. Child support, that stuff was kind of done. But we still needed to deal with the rest of the stuff. Because while I know you're used to just everything going your way, and like people sometimes not fighting against you because it's just easier sometimes to let you just go away. And so you're not used to people filing counterclaims against you and stuff, but it happens. Even though the Arizona rules required the court to allow me to withdraw the paternity petition, the judge refused to allow me to withdraw the petition. The court further set the matter for a 2-hour evidentiary hearing, which took place on June 10th, 2024. They did allow you not to be sanctioned under Rule 26. That's all that they allowed you to do. The court doesn't have to allow you to withdraw the petition. They just can't sanction you under that. And she didn't. And so far, everybody has agreed with her. While the paternity case was pending, Mr. Eckert's counsel provided a disclosed statement listing Michael Marraccini as a witness in the case. The portion of the disclosure statement referring to Mr. Marraccini is shown below. So it's sent to Randy Sue Pollock, and it lists the attorney, and it says this witness is expected to testify about his prior interactions with petitioner, her alleged 2 pregnancies during their relationship, and the subsequent litigation. Yeah, he was listed as a witness in a case. Way to prove that. Way to prove that he was a witness. And so he wasn't just stalking you for the hell of it. Like, that's a good way to show that he isn't violating a restraining order. You're proving Mike's case right here. I found the disclosure of Mr. Marraccini as a witness extremely surprising because at that time I had not spoken to Mr. Marraccini in several years. I would like to know the date of when several years is. Because if she says that she hasn't spoken to him and it is prior to the time she filed the last restraining order where she said he violated things, that shows that she committed perjury in that, but she hasn't spoken to him in several years at this point. To my knowledge, Mr. Marraccini did not know Clayton Eckert and did not have any personal knowledge regarding any of the issues involved in my dispute with Mr. Eckert. Furthermore, the disclosure statement falsely stated I had 2 pregnancies with Mr. Marraccini, and it implied that there was subsequent litigation relating to those pregnancies. This is completely false. The only litigation I have had with Mr. Marraccini is this matter, which I solely based on his threatening conduct towards me. He has never threatened you. And now you're just saying he threatened you. So is it because he threatened you or is it because he abused you? Like, which one is it? He is expected to testify about his prior interactions with the petitioner, her alleged 2 pregnancies during their relationship, and the subsequent litigation. So he is there to talk about his prior interactions with you, the 2 pregnancies you claim to have in the relationship, and the litigation, because this is still considered litigation, with him. He's not there to just talk about necessarily the pregnancies. And the pregnancies had to do with things. Whether you think it's important or not. Because Mr. Eckert asked the court to award him sanctions, I was forced to defend that issue. I eventually retained a lawyer in Arizona named David Gingras, who first appeared in the Owens v. Eckert in late March 2024. And that was a mistake. Because that made you worse off than you already are. I would not be bringing that man into this. At my request, Mr. Gingras attempted to interview each disclosed witness, including Mr. Marraccini. Because the only contact information provided for Mr. Marraccini was a lawyer named Randy Sue Pollock, Mr. Gingras contacted Miss Pollock to determine whether Mr. Marraccini intended to testify. What he intended to testify about. Well, see, Woodnick told you what he was going to testify: your prior relationship, the pregnancies, and the litigation that you had against him. That he stated that's what he's testifying about. That's what he's testifying about. And you know all about all those things because you're the one that did them. In response, Miss Pollock told Mr. Gingras that Mr. Marraccini knew nothing about Owens v. Eckerd and that he did not intend to appear in Arizona as a witness. Okay. This lawyer was mistaken and may not have even been his lawyer again at this time. But he was the attorney for him when you dealt with him. So things can be mistaken. On April 19, 2024, Miss Pollock sent Mr. Gingras an email confirming that Marraccini would not testify at the trial in Owens v. Eckerd. Despite this, just days after Miss Pollock stated in writing that Mr. Marraccini would not appear at trial, on April 24, 2024, Mr. Eckerd's counsel sent a new disclosure statement, which again listed Mr. Marraccini as a witness and explained for the first time that he intended to testify about my believed motivation in fabricating pregnancies to secure relationships. Your believed motivation. Well, yeah. And it's not necessarily believed anymore. It's proven. It's been proven that you do this. So it's got CO'd on there, Randy Sue Pollock, attorney at law, testify about the things that he said and the believed motivation in fabricating pregnancies to secure relationships. So he added an extra category about things that he was going to testify. That's why when Gingras and you sit there and like, we don't know what he's going to say. You do know what he's going to say. That's why you're scared. You were scared of the truth coming out and what he knew. Because he knew you the longest. And the only one that was actually in a relationship with you. After learning Mr. Marraccini's attorney had falsely told Mr. Gingras that Mr. Marraccini was not going to appear at trial. Okay, she didn't falsely tell that. At that time, she may not have known. And then she became aware. And then this is what happened. Doesn't mean she was saying falsely. As of that date, at that time, that attorney did not know that this was happening, is my guess. So she was like, yeah, my client is not testifying. I haven't heard anything about it. My attorney filed several pleadings, including a motion in limine and an emergency motion to strike, asking the court to exclude Mr. Marraccini on the basis of improper and untimely disclosure. Just a few days later, in early May 2024, I was horrified to learn that Mr. Marraccini publicly released nearly 2,500 pages of private text messages. I don't think it was 2,500 pages. Between 2016 and 2017. None of the private messages had anything to do with any of the issues in Owens v. Eckerd. Yes, it did. It showed your behavior. And when you compare those texts with Gillespie And Eckerd, in the way you acted in those, was your wishy-washy back and forth shit. It proves a pattern. It proves that this is how you act. So yes, it does have something to do with the case. Mm. Owens v. Eckerd and Mr. Marraccini did not release them in response to a court order, a lawful subpoena, or other valid legal request from Mr. Eckerd's counsel. These messages included hundreds of pages of private conversations between me and Mr. Marraccini, including discussions regarding sexual matters, medical issues. What medical issues did you have? Private family matters, and other highly personal and private topics. But you have put all that on display in all of your court filings. And all court filings are public. And so when you write stuff, people have the right to defend themselves. And did Mike put those out? I don't remember if Mike was the one that put that out or not, or if she's using it to say, a pseudonym is Mike and she just thinks it was Mike. Um, I want to think part of it was attachments in a legal filing, but I could be wrong. It is clear to me that Mr. Marraccini released these 2,500 pages of private messages for the sole purpose of harassing, humiliating, and terrorizing me. No. No, he didn't. His conduct had exactly the intended effect. Since Mr. Marraccini released these messages, they have been widely shared across the internet. Okay. By sharing our private messages publicly, Mr. Marraccini disclosed personal private conversations between us which had nothing to do with any issue involved in the Owens v. Eckerd case. As just one example shown below is a private text message I sent to Mr. Marraccini describing medical problems I was having, including an epileptic seizure. Mr. Marraccini publicly released my private medical information for no valid reason, resulting in it being published on the internet. Okay, that's talking about the seizure. The thing is you brought your seizures to the public and said that they were caused in the Uber thing. And then you said that your seizures later are caused by Mike Marraccini. So, yeah. If you say that this is where your seizures came from and this is where your seizures came from, that's two different things. And the Uber person having to pay for your seizures would be ridiculous if he didn't cause them. But making Mike Marraccini pay through a restraining order if the Uber person did it is not fair either. So you keep using this seizure thing that you supposedly have as a shield or a sword in every case that you have. It is difficult to put into words what an extreme and outrageous violation of my personal privacy Mr. Marraccini caused by his conduct. See, where's your proof that he actually put these out? Like, you're linking to the victims of Laura Owens. You're not linking to a post in which Marraccini posted anything. So you're going to have to prove that he posted this. This is not proof he did this. Mr. Marraccini, harassment, threats, and abuse go even further. The day before the June 10th, 2024 evidentiary hearing, Mr. Marraccini appeared in a video published on Instagram standing next to Mr. Eckerd and another male named Greg Gillespie, who I dated briefly in Arizona. This post is shown below. Mr. Marraccini is on the far right of this photo. Well, I'm so glad he can see him. Yeah, this is a good picture to post, you know. The please keep us in our thoughts and prayers as we head into tomorrow's court hearing. This has gone on for 10 years too long. The last thing we want to see is a fifth victim to have experience that we have. So this shows that Clayton Eckerd posted this. They said nothing. They are just witnesses in a case of Clayton. And then you have all these comments that are like, you need to be in prison. You're a liar, all that. Like, that's real smart to put in there. The fact that it was liked by over 17,000 people that think you're a cuckoo at the time of this, yeah, that's real good. Like, show the judge that everybody thinks you're a liar. And his attorney will get to use that you're being charged in another state for your pregnancy scams. And she states what the caption says and posted here. It's not just, we doesn't just include Gillespie, Eckerd, and Marraccini. It includes your past victims as well. There are 3 right here. They don't want to see a 5th one because they know of a 4th victim as well. And you have since gone after many other people since then as well. But relationship-wise, we know of at least 4. And it seems like there may actually be more, but at this time, we only knew about 4. So your math is not mathing here. After it became clear that Mr. Marraccini intended to appear at the hearing in Arizona on June 10th, 2024, I asked my attorney to take all possible steps to ensure that if Mr. Marraccini did appear, he complied with the terms of the OOP issued by this court, which remained valid and in effect at the time. You know what you're leaving out here is that you actually wanted to speak to Mike. You're leaving out that Gingras said that's okay if he sits in the courtroom, not outside the courtroom, because it would waste y'all's time. So there are things that could have been done that your attorney said no to, and your attorney is acting on behalf to you. So it's basically you saying things. And she could say, well, even if I show up somewhere, he's supposed to leave. And it doesn't matter if I invite to talk to him or I invite him over. If they have a restraining order, they're not supposed to go over there, or they're not supposed to be on the phone with them. Even if the person who initiated the restraining order says that it's okay, if the court didn't say it was okay, then it's not. But the thing is the court said this was okay. Like, there was a judge involved, there was security involved, everything was fine. At my request, my attorney, David Gingras, contacted court security to advise them of this court's OOP and asked them to provide assistance so that if Mr. Marraccini appeared as a witness, he was kept an appropriate distance away from me, as the court had ordered. According to Mr. Gingras, he contacted the Maricopa County Superior Court's head of security, provided a copy of the court's order, and was told that the court security would ensure the OOP was followed, but unfortunately that did not occur. Do you have statements from them saying that that's what happened? That they said that it was going to be, or hear you exaggerating and stretching the truth a little bit? Mike Marraccini didn't do anything to you on that day. He didn't even talk to you on that day. Okay. In addition, on May 6, 2024, Mr. Gingras sent an email to Mr. Marraccini's attorney explaining his concerns that it appeared Mr. Marraccini intended to travel to Arizona to violate this court's OOP. He was not flying there to violate his OOP. He wasn't like, there's nothing going on June 10th. I'm just going to fly to Arizona for the hell of it just to violate my restraining order and just to go fuck with Owens. No, that's not what happened. He was subpoenaed to be in court. Therefore, he needed to be in court. He'd flow there specifically to violate his restraining order. No. In response, Mr. Gingras told me Miss Pollock stated that Mr. Marraccini would not agree to interview or deposition despite his being required by the rules, and that according to her, Mr. Marraccini intended to simply show up at the hearing despite he had not been served a valid subpoena requiring him to appear in Arizona. Well, he had a subpoena. I'm still not quite sure necessarily what a valid subpoena is. Like, you were told, he was told, like, he got it, like, it's signed by the court. Like, what are you, like, I don't understand. And if it was a huge problem, then maybe you should have called the San Francisco people and been like, hey, was it okay for him to actually go there? Like, oh, I hate that I'm saying like so much, but why didn't Gingras call San Francisco? Like, why didn't you call San Francisco and ask what you can do? And I'm still not understanding why you would call police and security and all that on Marraccini, but at the same time, you have one against Gillespie. So you were okay with Gillespie, but not okay for this during that time period? On the morning of June 10th, 2024, I appeared at Maricopa County Superior Court for the evidentiary hearing in Owens v. Eckerd. As I am waiting outside, Mr. Marraccini came within 300 feet of me in direct violation of this court's OOP. At my request, Mr. Gingras reported the violation to the court security, gave them a copy of this court's OOP, and asked security to enforce the court's order. And court security staff informed Mr. Gingras they could not enforce this court's order and that the only enforcement option was to contact Phoenix Police Department, which Mr. Gingras did immediately. Yeah, they just told y'all to go fuck yourselves with this restraining order. I doubt that's what they told you. A few minutes later, officers from the Phoenix Police Department arrived, and Mr. Gingras again provided them with a copy of this court's OOP. He explained that Mr. Marraccini had violated the order and asked them to enforce it. Mr. Gingras further provided officers with a copy of a relevant part of the Federal Violence Against Women's Act, 18 U.S.C. 2265, which provides in part any protection order issued that is consistent with subsection B of this subsection by the court of one state, Indian tribe, or territory. The issuing state, Indian tribe, or territory shall be accorded full faith and credit by the court of another state, Indian tribe, or territory, that enforcing state, Indian tribe, or territory, and enforced by the court and law enforcement personnel of the other state, as if it were the order of the enforcing state. Despite the fact that this court's OOP was legally required to receive a full faith and credit in Arizona, the Phoenix Police Department refused to enforce it, probably because he had a subpoena that said he could be there. But once again, y'all only give half the information. Therefore, on the morning of June 10th, 2024, Mr. Marraccini sat inside the courtroom at Maricopa County Superior Court, approximately 20 to 25 feet away from me. For a period of approximately 2 hours, after personally observing Mr. Marraccini violating this court's order, my attorney asked the judge hearing the case to once again enforce this court's order by excluding Mr. Marraccini from the courtroom without any explanation. Judge Mata denied that request, and she allowed Mr. Marraccini. She did give an explanation. She already addressed it in chambers with y'all. She had already said that he is allowed to be a witness. She made her order that he was allowed to testify in the case if they needed to or had time to. She allowed Mr. Marraccini to remain less than 300 feet away from me during the entire 2-hour hearing. While I was testifying on the stand, Mr. Marraccini sat in the room approximately 40 feet away from me. I'm glad you have your measuring tape out. I didn't see that anywhere on you when you did your little spinny spin. He glared angrily at me the entire time. This caused me so much emotional trauma and anxiety that I lost my composure and I was unable to complete my testimony without calling for a recess. Absolute bullshit. The reason that she broke down is because there was rumblings from the crowd. They were not from Marraccini. And she also didn't like the question. And she was fucking up on the stand. It had nothing to do with Mike Marraccini. And the judge should be allowed to review this proceeding. Somebody send him the hearing, or at least this clip, and show that her breakdown had nothing to do with Mike Marraccini. Nothing. It's on video, woman. Mr. Marraccini knew he was committing a federal crime by traveling to Arizona with the intent of violating this court's order. He did not drive there or travel to Arizona with the intent of violating the order of protection. That was not his intent. His intent for going there was to testify as a witness against you. That is backed up in court documents. It's in the subpoena. The judge can talk to the other judge. That is not what happened. You have, and most of the time we can say you don't know his intent, but the intent was clearly stated. It's insane. This court's OOP expressly informed Mr. Marraccini of the fact as shown on the face of the order here. Warnings and notices to the restrained person. If you do not obey this order, you can be arrested and charged with a crime. Okay. You can go to jail or prison or pay a fine. It is a felony to take or hide a child in violation of this order. Well, Owens hides childs in violations of everything. If you travel to another state or make the protected person do so with the intent of disobeying this order, you can be charged with a federal crime. Well, good thing he had a subpoena, and his intent to travel there was not to do shit to you. It was to testify. Because the court said you have to come. So, yeah, he didn't have the intent to go there to do that. So, it's not a crime. Prior to Mr. Marraccini traveling to Arizona to violate this court's order, my attorney made extensive efforts to work with Mr. Eckert's counsel to ensure that Mr. Marraccini could testify if properly summoned to do so, while doing so in a manner that did not violate this court's order. Among other things, Mr. Gingras, who is licensed to practice law in both Arizona and California, maybe not for long, offered to submit a stipulation to this court to modify the OOP to permit Marraccini to appear as a witness in the Arizona case. Mr. Gingras explains this issue further in his declaration submitted here within. Oh, God, Gingras said shit. In addition to violating the court's order on June 10th, 2024, Mr. Marraccini has also engaged in a course of conduct which has harassed me by posting extensively about me on social media. Mr. Marraccini accused me of lying to this court about the facts supporting the OOP issued by the court, which Mr. Marraccini initially stipulated to. He is allowed to say you're a liar. He is allowed to tell his story. He did not send this story to you. He did not send messages to you. He did not say, hey, Laura Owens. None of that. He told his story to a reporter, a journalist. But you want to be petty and call it a blogger. That's funny because she doesn't have a blog. Your attorney has a blog. And YouTube is not a blog. It would be a vlog, if you wanted to say that, a video, but it's not a blogger. She does not even have a blog. You don't even know what anything is. Accuse me of lying to this court about the facts supporting the OOP, which he has stipulated. For example, in June 2024, Mr. Marraccini appeared in a 2.5-hour YouTube video interview with a blogger named Megan Fox. That's a lie. Like, just because that's not what she is, but you want to, that's how you're going to hit her and make fun of her, is by calling her a blogger. In this video, which remains online here, Mr. Marraccini talked about me extensively, even claiming that the OOP issued by this court was completely fabricated. Well, it was. And she highlights at 2032. He says, going to tell you something because I don't want this to come out amount months down the line and be in pretty intertwined by this point. But I said, like, I'm dealing with somebody who has a restraining order against me, which is completely fabricated. I think you don't need me. Yeah, okay. Yeah, he's allowed to speak what he thinks. It's called an opinion. He's not allowed to he doesn't have to like keep your name out his mouth. He just can't contact you, which he doesn't. In addition to making false public statements accusing me of lying to this court, well, you did. Marraccini has also repeatedly posted private photos of me online under the pseudonym Honk My Meat. You have to prove that Marraccini is Honk My Meat, first of all, and justice for Honk My Meat. Because they are getting trashed about this. And now Honk My Meat is possibly going to have to go testify. Now, I don't know if they're going to get on the stand and be like, I am Honk Thy Meat, and the subpoena is going to go to Honk My Meat, not the actual name. Like, okay, like you cannot just throw out accusations that you cannot prove. Below is an example of a photo of me that Mr. Marraccini posted under that pseudonym. I know Mr. Marraccini posted this photo because he is the one who took the image during a vacation we took to Iceland while we were dating. I don't even know what that picture is. But you might have posted this photo, or it's somewhere out there publicly. Mr. Marraccini has also published multiple other photos of me, my family, and even my pets using the Honk My Meat pseudonym. Using the same account, Mr. Marraccini has posted statements on social media offering to discuss why the cheating may have happened, which I understood was a reference to infidelity that occurred with a member of my family during the time that Mr. Marraccini and I were dating. So apparently there was somebody was cheating on somebody while Owens and Mike were together. I'm giving my info free of charge and want to discuss if anyone wants to talk about why the cheating may have happened. Okay. Mr. Marraccini also shared private text messages he exchanged with my father, which he gave to Megan Fox, who referred to him as emotionally abusive. Ron Owens sends emotionally abusive texts to Mike Marraccini while his stepfather was dying. These were in public documents that were filed in court. Okay. Megan Fox refers to them. He's allowed to share things. Mr. Marraccini has also posted statements on social media referring to me as dangerous is an understatement. He is talking to Greg Gillespie, and he is allowed to talk about you because he is not contacting you, but he is allowed to talk about you. That's his First Amendment right to be able to talk about you. Like you. Taken together by Mr. Marraccini's actions have been absolutely terrifying to me. First, he unquestionably committed a federal crime No, he didn't. Because there was no intent to travel to Arizona to break the OOP. And then she cites interstate violation of order of protection. Still saying with the intent. It's not the intent to do that. She does not understand shit. She just thinks, oh, you go somewhere, that's it. No, there has to be an intent there. When Mr. Marraccini traveled from California to Arizona on June 10th, 2024, he did so knowingly that the court had issued a valid lawful order prohibiting him from engaging in precisely that conduct. He never asked this court to modify the OOP, and his attorneys even rejected my lawyer's offer to jointly request permission from this court to allow Mr. Marraccini to travel to Arizona. They don't need that court's permission because they're a court themselves. Mr. Marraccini never asked the Arizona court to modify the court's order, although it's my understanding the Arizona court had no authority to ignore or change this order, although this is exactly what happened. They didn't change the order. They sure as hell didn't change it. And witnesses are allowed to go testify against people. Like, if people that had restraining orders against each other could never testify against each other in court, like, what? That is just not something that can happen because people have to be able to say stuff even under all that. They're just not allowed to contact you outside those means. He was going to be talking to the judge and the lawyers. He was not even going to be talking to you. Mr. Marraccini's actions, particularly with respect to his decision to publicly release the personal private text messages between us, has been absolutely devastating to me. I have hurt feelings. His conduct has caused me severe emotional distress and has made me feel like my personal privacy is lost forever. Maybe you shouldn't have gone to the media. Your privacy would still be there if you didn't go to the media. But you wanted to make this public. Nobody would even know about nobody would know about Mike Marraccini or Greg Gillespie or any of this had you not gone public. Everything is out there because of your actions and only your actions. For the reason she wants the restraining order permanently, further requesting that this court find Mr. Marraccini violated his court's order and that he engaged in interstate travel with the intent of violating the court's order. I further ask the court to refer Mr. Marraccini to the United States Attorney's Office in San Francisco for investigation. Yeah, let them investigate him and you because you're going to be a part of that little investigation, and that's not going to turn out so well for you. And if appropriate, criminal prosecution based on his violation. I declare under penalty of perjury under the laws of the United States of America that the foregoing is true and correct. Well, it's not. You've lied and omitted many a times in this. Her exhibits. Okay. Exhibit A. Okay, that's her original exhibit. Okay. Here is the declaration of David Gingras. All right. Yay. Mike is over $9,000. So that is good. That is amazing. Let's keep it up. All right. The Declaration of Gingras. I wonder if he was drunk when he wrote this declaration. Was he driving and drinking at the same time while writing this declaration? Who knows? My name is David Gingras. I am a United States citizen, a resident of the state of Arizona. I am over the age of 18, and if called to testify in court or other proceedings, I could and would give the following testimony, which is based on my own personal knowledge. Your knowledge is based on hearsay. I am an attorney, and I can practice law in California since 2002 and in Arizona since 2004. I graduated from the University of San Francisco in May 2000, where I was a member of USF Law Review for 2 years. I am an active member in good standing. I mean, is good standing just mean that your bar license is active? Because I think good standing could be an opinion. I am also being investigated by the Arizona Bar currently. I am admitted to practice. Can you just practice there all the time, or do you have you just okay, I guess he's applied to all the different circuits. Okay. I previously represented a woman named Laura Owens in a case filed in the Maricopa County Superior Court here in Phoenix entitled Owens v. Eckert. The online docket for this case is available here. We're all familiar with that docket. Owens v. Eckert was a paternity case Laura filed on August 1st, 2023 in her petition. Laura claimed she was pregnant after a one-night sexual encounter. Thank you. At least he says one-night stand, not one-night relationship or whatever she wants to call it. When Laura filed the case on August 1st, 2023, she was pro se. I did not represent her in any capacity. Clayton was pro se as well. Why did they need to know about the entire case? Laura claimed while she had a miscarriage. This is Eckert filed counsel who appeared in the case around mid-December. Mr. Eckert's lawyer accused Miss Owens of fabricating her pregnancy. So that's funny. Like, there is proof in these documents that Mike Marraccini has said she's fabricated things, and now Mr. Eckert has said she has fabricated things revolving around pregnancy. So there's two guys so far that there is proof of that she has fabricated things against, just within this 101-page document. Okay. Talk about Rule 26. You know, this should have been dismissed. I didn't represent her at the time of when she tried to dismiss it, but the safe harbor should have happened. You know, they filed a motion for 26 sanctions. The court denied her to be able to dismiss it. And then he says, I retained to represent Laura on March 25th, 2024. I appeared that same day. Then he attaches the appeals document. Okay. After I appeared in the case, I learned that Mr. Eckert disclosed several witnesses, including a man named Michael Marraccini, According to Rule 49 of the Arizona Rules of Family Law Procedure, all parties in a family court are required to disclose certain information to other parties, including the following: disclosure of witnesses. Each party must disclose the name, address, and telephone numbers of any witness whom the disclosing party expects to call at trial, along with statement fairly describing the substance of each witness's expected testimony. The Arizona Supreme Court has interpreted this disclosure requirement to require specific disclosures of the substance of witness testimony, not generalized, non-substantive references, such as saying a witness will testify to all matters. Well, Winnick didn't say that Marraccini was going to testify to all matters. He wrote down specifically things that he was going to testify about. So, he cites a case saying finding disclosure statement did not contain sufficient detail to comply with the rule, where it simply stated the witness would testify about all matters referred to in deposition or all matters in complaint of which the witness has knowledge. Holding adequate disclosure should fairly expose the facts and issues to be litigated, as well as the witness to exhibit to be relied upon. Well, Marraccini also said, hey, I am going to testify about this, and this. You also knew about the laptop, like you knew specifics. Based on my review of the disclosures provided Mr. Eckert, it was clear his disclosure failed to meet the specificity requirements of Rule 49 because Mr. Eckert disclosed literally nothing more than a single sentence suggesting that Mr. Marraccini intended to testify regarding his prior interactions with Laura. This told me nothing about the substance of Mr. Marraccini's expected testimony. The relevant portions of Mr. Eckert's initial disclosure regarding Mr. Marraccini is also shown. He didn't just say his prior interactions with Laura. He said her alleged 2 pregnancies during their relationship and subsequent litigation. Those are the things he is going to testify. And then eventually the laptop was added. Or actually, no, I don't know that he was going to testify to the laptop. The other guy might have been. Because Mr. Eckert failed to comply with the disclosure requirements of Rule 49, I could have simply asked the court to exclude Mr. Marraccini as a witness on that basis alone. And however, because I wanted to know what Mr. Marraccini had to say, I picked up the phone and called the lawyer listed as the contact person. Miss Pollock, said that he would not be appearing at trial as a witness. I thanked Miss Pollock for providing me this information, and I asked her to send me an email confirming what she told me. And she sent the email, which we saw earlier. And he's attaching it here as well. My client will not be testifying. Despite this, just a few days later, I received a new disclosure statement from Mr. Eckert, which once again continued to list Marraccini as a witness and provided an extremely small amount of additional information, stating that he intended to testify as to Laura's believed motivation in fabricating pregnancies to secure relationships. So they gave you more specification. The new disclosure was directly contrary to what what Miss Pollock had told me just days earlier. Based on this, I became extremely concerned. So again, I contacted Miss Pollock by phone on May 6, 2024 to seek clarification. During the phone call, Miss Pollock was extremely angry, defensive, and agitated. I found this extremely odd because my single prior conversation with her was exceptionally brief and cordial. Well, maybe she found out about you. During the call, I told her that if Mr. Marraccini intended to appear as a witness, that was fine with me. Okay. So you're okay with him being a witness, but you called the cops on him. All right. I explained I had no concerns with Mr. Marraccini testifying as long as he complied with the disclosure requirements of Rule 49 by providing a specific summary of expected testimony. Are you going to provide the email that Marraccini sent to you telling you everything? And I also informed her that Miss Owens had a valid existing restraining order from this court, which required Mr. Marraccini to remain at least 100 yards away from her at all times and to otherwise not have any contact with her without prior permission from this court. I told Miss Pollock several times that I had no objection whatsoever to Mr. Marraccini testifying in Arizona, provided he did so in a manner that complied with the Arizona rules and did not violate this court's order. As to the issue of disclosure, during the phone call, I asked Miss Pollock whether Mr. Marraccini would agree to either an informal interview by phone or a deposition, assuming he would not agree to an interview. Nobody wants to talk to you on the phone. There's no protections there. Miss Pollock specifically told me, no, we were not willing to cooperate with you. I responded by telling Miss Pollock that compliance with Arizona rules was not optional, and that if Mr. Marraccini would not agree to be interviewed or deposed in violation of Arizona disclosure rules, that I would object to his participation at trial as the rules expressly allow. It is not required that they have to be deposed. It's not a requirement. It can be ordered, but he wasn't ordered to sit for a deposition. And you got discovery from things from him. You also didn't want to look at certain discovery. So that's on you. In response, Miss Pollock told me that under no circumstances would Mr. Marraccini agree to comply with Arizona. Yeah, she just said he is not going to agree to follow any rules with the courts. Yeah, that's exactly what the attorney said, I'm sure. Because if the court would have told him he had to, then he would have. But apparently, Miss Pollock said that he was not going to comply with Arizona's procedural rules applicable to a witness testimony, but instead he was planning to simply show up in Arizona as a non-subpoenaed spectator. Well, he was subpoenaed, so that statement is not true either. I don't know anything about Miss Pollock. I think she originally gave bad advice to Marraccini when all this started years ago in 2018. I don't think she was in the loop on this case for a while. Then apparently she got caught up, but I don't think she's just like, fuck the judicial system. Who cares what they have to say? I found Miss Pollock's remarks extremely disturbing because, among other things, Mr. Marraccini's threat to travel from California to Arizona for the purpose of he wasn't going there for the purpose of violating the court's order. That is it's just not true. It's so disingenuous. To ensure that there was no confusion about my position on these issues, immediately after speaking with Miss Pollock by phone, I sent her an email on May 6th. A true and correct copy of this email is attached hereto as Exhibit A. In this email, I documented my conversation with Miss Pollock, including each of the above points. I also attached copies of the original and renewed domestic violence restraining orders entered against Mr. Marraccini by this court. In addition to repeating my position that Mr. Marraccini was obligated to comply with the disclosure requirements of Arizona rules or Arizona law, if he wanted to testify as a witness at trial, I also explained the following points. All right. So he says, also, and just to be clear, I am not, under any circumstances, suggesting Mr. Marraccini should not participate in the trial if he has relevant information. All I'm saying is that if he wants to testify, he needs to do so in a manner that complies with the rules and the laws. This is a mandatory to ensure basic fairness to all sides. Oh, excuse me. Finally, please note that it is a felony under Arizona law for any person to unlawfully withhold testimony to evade legal process to appear and or to fail to appear when legally summoned. For avoidance of any doubt, nothing in this email should be construed as an attempt to cause Mr. Marraccini not to appear. On the contrary, I would very much like him to appear. Okay, he appeared. You're like, he is supposed to appear if he is legally summoned. And he can evade legal process to appear or fail to appear if he's legally summoned. Well, he was legally summoned. A manner that complies with the rules, including the rule that requires the prompt disclosure of the substance of his testimony and the rule which entitles me to interview him prior to trial. You don't get to talk, you don't necessarily get to interview him. Miss Pollock never replied to this email, and I had no further communications with her. Yeah, because she don't want to talk to you. However, the following day, on May 7th, 2024, I received an expert disclosure from Mr. Eckerd's counsel, which included a report from a computer expert named John Berryhill. A true and correct copy of this expert disclosure is attached here too as Exhibit B. Oh, he attached the Berryhill files? The computer files? Okay. The sole subject of the Berryhill report was a laptop allegedly provided to him by Mr. Marraccini. According to Mr. Berryhill, the laptop contained nearly 25,000 pages of private text messages exchanged between Mr. Marraccini and Miss Owens while they were dating in 2016 to 2017. When I saw the Berryhill report, I was astonished because it represented such a blatant and intentional violation of the family law disclosure rules. Bearing in mind that Owens v. Eckerd was filed on August 1st, 2023, the rules required Mr. Eckerd to promptly disclose all evidence he intended to use at trial. Well, this is something that they didn't know of back then, that they just found out that he still had this laptop from back then. He intended to use at trial. Rule 49 specifically required Mr. Eckerd to make this initial disclosure within 40 days after his initial response to the petition, which would mean by September 2023. After any supplemental disclosures were raised or were required to be made in a timely manner, which the rule defines as in no event more than 30 days after the information is discovered by or revealed to the disclosing party. Well, it was within the 30 days. It was within like a week of when Marraccini realized he had this laptop and he got it analyzed by a forensic analyst, and then it was turned over to Clayton Eckerd defense team, and then it was disclosed to you. It was in 30 days after the information was discovered. This laptop was discovered within a certain amount of time, and within a week's time of realizing this, it was disclosed. Here, rather than complying with the disclosure obligations, it was obvious Mr. Eckerd and Mr. Marraccini conspired to withhold and conceal evidence from Miss Owens and myself until literally 3 days before the disclosure of discovery. So you're lying and exaggerating truth as well, just like your client. Oh, before the close of discovery, he gave me information. The court had previously scheduled the close of disclosure or discovery on May 10th, 2024. And you got it on what, May 8th? Yeah, within the time of discovery. Immediately after receiving some similar disclosures relating to Mr. Marraccini, which were sent a few days before the full Berry Hill report, I filed an emergency request to strike Mr. Eckerd's pleading and a request for an immediate telephonic scheduling conference to discuss Mr. Eckerd's violation of the disclosure rules. Well, he didn't violate them because they didn't know this laptop was even in existence. So, yeah, it was denied. Unfortunately, despite seeking emergency relief, the trial court waived several weeks before denying my emergency request without explanation. Well, the court doesn't have to explain to you why they denied it. Once it became clear that Mr. Marraccini intended to violate this court's order by traveling to Arizona to appear at a hearing on June 10th, 2024, without lawful grounds for doing so, Laura told me she did not believe she could participate in the case unless we did everything possible to ensure Mr. Marraccini complied with this court's order. To comply with Laura's request, shortly before the June 10th hearing, I contacted Maricopa County Superior Court Security Department to advise them of the situation to seek their assistance. You also tried to get him striked as a witness, and the judge said no, he can be a witness. I was told the security that he understood the situation and they would be happy to ensure compliance with any valid court orders. Officer Gibbs asked me to provide him with a copy of the court's restraining order, which I immediately did. Yeah, but when you were talking to him, you were saying that he was like a non-subpoenaed witness, like that he was just going there to go there. When he wasn't just going there to go there. He was going there because he was subpoenaed to be here for the trial or the evidentiary hearing. On the morning of June 10th, 2024, Laura told me that she saw Mr. Marraccini violate this court's order by coming less than 100 yards away from her in the parking lot outside the courthouse. Laura told me that if Mr. Marraccini was allowed to violate his court's order and harass, threaten her in any way, she did not believe she could participate in the hearing set for 9 a.m. that morning. Yeah, that's what she seemed to be doing while she was laughing. At Laura's request, I contacted court security to explain the situation and asked them to enforce this court's order. Court security told me they did not believe they had authority to enforce an out-of-state order, and that the only option for help was to contact the Phoenix Police Department, which I immediately did. Okay. Officers from Phoenix Police Department arrived within a few minutes. At that time, I provided them with a copy of the court's order. I explained that he had violated by coming in within 100 yards of Miss Owens, and I asked them to enforce the order as required by federal law. The responding officers told me they would defer any enforcement to the decision of the trial judge. After some delay, the officers informed me that Judge Mata had instructed them not to enforce this court's order. The officers declined to offer any further explanation. Shortly before the evidentiary hearing began, I again raised the same issue with Judge Mata, and I told her that in my view was under federal law, she was required to give full faith and credit to the court's order by enforcing it as written. Unfortunately, Judge Mata denied that request without any explanation. Therefore, Judge Mata allowed Mr. Marraccini to sit in the small courtroom approximately 20 feet away from Laura. Mr. Marraccini did not, in fact, testify as a witness, and Mr. Eckerd's counsel never obtained a valid California subpoena requiring Mr. Marraccini to travel to Arizona for this appearance. I don't think they have to get a California subpoena if they're subpoenaing him in Arizona. That makes no sense to me. Why would they need a California subpoena? Similarly, Mr. Berryhill never testified as a witness, and his expert report was never admitted in evidence. Despite this, I am informed that the full 2,500 pages of text messages appended to Mr. Berryhill's report were later leaked on the internet by either Mr. Marraccini, Mr. Eckerd, or someone else working with them. Well, it's evidence in a case. It is submitted in a case, like, it was filed in the court. Like, it wasn't just, "Hey, look at this." No. This was a part of Barry Hill's report. So, once again, it wasn't just him being like, "Hey, look at all these." No, it was the full report. So, they lied about how this 2,500 pages of texts ended up getting released. It was because it was in a court case, and court cases are public. We're allowed to see a report. And I believe it was after the case had been over with that we got access to these. And so when the case is final, you're allowed to, get information about things because there's no reason to keep them hidden anymore. The stuff's public. When Laura took the witness stand, she was forced to look at Mr. Marraccini sitting approximately 30 to 40 feet in front of her for the entire duration of her testimony. No, she was not. During questioning and cross-examination, Laura became so upset that she lost her composure and was unable to continue. As a result, I called for a recess, which was granted. No, that was not why you called. You weren't like, Mr. Marraccini caused her to be upset. That's nowhere on the record. During the recess, Laura, her mother, and our medical expert, a retired doctor, assembled in a side room. Laura was shaking almost uncontrollably, and she told me that she did not believe it was possible for her to continue testifying with Mr. Marraccini sitting there glaring at her. And guess what? You never asked the judge during this time period, "Hey, so she can finish testifying, can we have Mr. Marraccini go sit not in the courtroom?" Like, you never even brought that back up. After extensive efforts from myself and our medical expert, we were eventually able to calm Laura down enough that she was able to complete her testimony, but it was clear to me that the traumatic nature of the situation directly affected Laura's testimony and demeanor in court. Okay. Based on my personal observations of Laura and discussions with her on June 10th, 2024, I have no doubt that Mr. Marraccini's actions that day were extremely upsetting to her. Okay, they hurt her feelings. I believe Laura is particularly concerned that Mr. Marraccini knowingly and intentionally violated this court's order by traveling to Arizona for the purpose of harassing her, despite knowing in advance that doing so constituted a serious federal crime. I declare under penalty of perjury under the laws of the United States of America that the foregoing is true and correct. That is the email. This is the Berry Hill thing, which, it's interesting. You attach the Berry Hill thing, but you didn't attach the rest of the conversations. Like, why didn't you attach the 2,500 pages? Like, because maybe the judge would like to see that. So that is the restraining order renewal that Owens wants. Let's see where we're at in the fundraiser. 36% raised. All right. There also was okay, that's the GoFundMe. Okay. let's also talk about this order that just came down in Owens' criminal case. So I'm going to share screen. All right. So all right. So this came in on, or it was filed on 7/11/2025, the state's motion for protective order, which is not the same as what we just went over. It's not the same type of protective order. So it says protects a victim's right to privacy by requiring law enforcement and prosecution agencies redact victim identifying and locating information from records disclosed in the criminal case. Footnote 1 was recently amended to prohibit the dissemination of any victim identifying and locating information to not only the defendant, but also precluding dissemination of this information to the defendant's lawyer or to the defense attorney's staff. So they do not get to have the addresses and stuff of the like victims in the case, so that they can't go find them. Rule 39B11 of Arizona Rules of Criminal Procedure similarly gives the victim the right to require during discovery and other proceedings that the prosecutor withhold. Oh, hold on. Withhold victims identifying and locating information. In other words, she does not get to get the location information and details, and her attorney does not get these things of the victims. They can know that the victim is testifying. They can know the victim's name. They do not have a right to their information, so that it does not get shared, and she cannot go do anything to them. The victim's right to require that the protection withhold identifying and locating information is not absolute, however, and must give way where the defendant has a constitutional due process right to the information. Accordingly, Rule 39B11A permits the court to order disclosure of the victim's identifying and locating information as necessary to protect the defendant's constitutional right. If the court orders disclosure of the victim's identifying and locating information, defense counsel shall not disclose the information to any person other than counsel's staff and designated investigator. The information can be disseminated to the defendant without prior court authorization, or cannot be disseminated. So, in order for them to get this information, the court is going to have to give permission for the defense to have this, or and they are not giving it over until the court says they have to. In this case, the state and law enforcement are in possession of victim's copy of laptop, which contains victim's identifying information. The victim's copy of laptop contains hundreds, thousands of pages, gigabytes of data, which include the victim's identifying and or locating information due to the nature of the media format and other or the quantity of the media data. The victim's identifying and or locating information cannot be redacted. Because the state is required to disclose victim's copy of laptop via axiom under Rule 15.1 of the Arizona Rules of Criminal Procedure, and because defense counsel may find information within this victim's copy of laptop via axiom that implicates Brady v. Maryland. You have to turn over things, you have to disclose things such as that. So they're going to have to figure out something on this. and its progeny. The state respectfully asks this court order victim's copy of laptop via Axiom to be disclosed under Rule 39B 11A with the appropriate protective order under Rule 15.5 to keep defendant from viewing any of the victim's identifying or locating information by limiting disclosure to defense counsel, counsel staff, and counsel's designated investigator. So it is the Rachel Mitchell and Edward Leiter that are asking for this. And I just shared a whole bunch of stuff. So they want certain stuff protected against, maybe some redactions or things like that. Only certain people are allowed to look at it. There's personal information that doesn't need to be shared, whether it is to keep it away from the defendant or it is to keep away from the public, things like that. I can see the defense themselves wanting a protective order or at least having filings under seal so that they don't get out to the public, because they're going to want to try to keep this stuff hush hush and they're going to want people not to talk about it. And we'll see what the judge and stuff decides to do with this stuff as this case goes along. But that is where we are at thus far. Again, please go donate to Mike Marraccini's defense fund so that he can fight against this cray-cray woman. Maybe we will see charges for her in California. Hopefully we get a judge telling her to fuck off there, and he gets some type of win. Whether it's just, no, we're not renewing this, or if it's something else. Hopefully all of this just comes to an end on that side of things. Because Owens is going to be fine without a restraining order against her, without having a restraining order against people, because people seem to run from her. And then when they try to run, she's like, no, I don't want you to run. But I want it to look like, you're trying to stay, but I know you're actually running. Like, she wants to make herself seem so desirable that all these men just can't leave her alone. They're so obsessed with her, when it's the complete opposite. So that is going to be it for this video. If the more that stuff comes out, we will let you know. I am going to be putting out some videos that have to do with the Sandra Birchmore case that we have covered on this channel. She is the girl that was groomed in the Police Explorers program. And then those same police officers, one of them ended up killing her, and she ended up pregnant. A bunch of stuff has come out in that case, and there's another officer that was grooming her that I want to go over those documents about his disgustingness against her, because Sandra Birchmore still is seeking justice and deserves it as well. But I will see you guys later. Try to stay cool. It's hot here. And send positivity. Bye.